morning, everyone. Thanks for joining us on this initial webinar. It's going to be the first of a series that the firm puts on, and today's topics are going to be about the FTC non-compete rule and a wage and hour update, both of which were issued in late April. For those of you who don't know me, my name is Mike Schauer. I'm a partner here at the firm in the business and real estate section. I handle employment matters for our clients as well as general corporate matters. So where we're going today, we're going to start by talking about the FTC rule. We're going to go into that with a little bit of detail. And then after that, we're going to talk about the wage and hour update. So starting on the FTC rule. Now, I suspect many of you have been inundated with emails and press releases and news alerts and editorials and op-eds and everything else. And I'm sure that there's a little bit of confusion out there for at least some of you. So the goal today is going to be to clarify what the FTC final rule actually says. And here's what it does at a high level. It bans non-competes. It prohibits employers from representing that a worker is subject to a non-compete clause. It also requires employers to send notice to affected persons with qualifying non-competes. And senior executives are treated differently, but are still subject to the rule. So I guess before I dive in more detail, what I mean by ban or making impermissible, I'm talking about enforcing, entering into, or attempting to do any of those things. And I use the word ban because it's supposed to be broad. The definition of a non-compete, which we'll get into in a couple of minutes, is broad. And both in terms of its application, but also that it's going to apply on a national level. So how did we get here? I think a little bit of context is helpful. So previously, the enforceability of non-competes was left to the states. So in Ohio, non-competes were enforceable generally, provided that they were reasonable and protected a legitimate business interest of the employer. Other states like California and Massachusetts, non-competes were generally not enforceable or very difficult to enforce, right? And then the FTC, a federal agency, got engaged in administrative rulemaking. And in a nutshell, what that means is that the administrative agency decided to issue an initial rule. The initial rule contained rationale for why they thought it was necessary, and then it was published for public comment. After the public got a chance to weigh in, the FTC collated all of those comments, reviewed them, and then issued the final rule. So with respect to timing here, the initial rule from the FTC was issued in January of 2023. Over 26,000 comments were submitted, many in support, many against its enactment. And then the FTC took the better part of a year to review all of that before publishing the final rule in late April. Now, I keep coming back to the word broad, and that's important because the final rule here would preempt state-specific laws. So not only is the definition of a non-compete broad, it also means that they're clearing the playing field for the federal perspective. So state-specific laws will become meaningless, really, because non-competes will no longer be enforceable. So here's the definition of a non-compete underneath the final rule. It's a term or condition that prohibits, penalizes, or prevents a worker from seeking or accepting employment in the United States or operating a business in the United States after the end of the worker's employment. There's a couple of key things here, right? So the prohibits, penalize, or prevents a worker. So prohibit or penalizing is pretty straightforward, right? The preventing a worker from doing one of these things is broader, and that's intentionally so. So the FTC is concerned about other contractual provisions that are not necessarily called a non-compete, but still act like that. So we're talking about your non-solicits, your confidentiality provisions, other restrictive covenant agreements, where the clause is so broad or onerous that it effectively stops somebody from working. So the key takeaway here is it doesn't matter what they're calling something, it matters what it does, which is, again, significant broadening. There's also a pretty broad definition of what a worker means here, which further expands what the FTC rule is going to govern. So employment within the context of the FTC rule would mean work for a person. A worker means any person who works or previously worked for the employer regardless of title, and it expressly includes employees, independent contractors, externs, interns, and others such as volunteers. So for anyone that thinks that they're going to be okay because most of their work's done by, say, independent contractors and their employees don't really sign non-competes, it's still not going to work. You have to look at what the contracts say and what they end up prohibiting. Now, there are exceptions to the final rule, which is a good thing, because it allows some aspect of the old way of doing things to continue. So with respect to senior executives, I've included them here as an exception, even though they're not technically an exception under the rule. It's just because they're treated differently. The true exceptions would be the pre-existing causes of action, the sale of a business, and then a good faith basis that the rule wouldn't apply. So the first exception I want to go through would be for senior executives, and these are workers who are in a policy-making position. And when I say policy-making position, I mean think of the C-suite executives, your CEO, president, chief financial officer, something along those lines where they actually have decision-making authority at the company. It's also workers who made at least $151,164 in total annual comp. And crucially, it's a worker that entered into a non-compete prior to the effective date of the rule. So this is not going to cover, for example, your shop manager or floor manager or something along those lines, or your manager of, say, your restaurant or store, unless they are in a CEO or CFO position. Now, the other exceptions to the rules are right here. The first one is in connection with the sale of a business. So for mergers or acquisitions, I would expect non-competes to remain largely enforceable because the sale of an ownership in a business entity or stock sale, or all or substantially all of an entity's operating assets, your asset deal, are explicitly carved out from this rule. The other exceptions here would be for an existing non-compete that was violated prior to the effective date of the rule. So if you are engaged in pending non-compete litigation, or if one of your employees has breached their non-compete, or I should say former employee, you still have a viable cause of action and you can pursue that person for breaching the contract. The last exception here is a good faith basis that a non-compete clause isn't subject to the FTC rule. And I've included it just because it's within the actual text of the FTC rule, because I always get a little bit nervous surrounding it, and that employers could view this as a chance to bury their head in the sand and say they didn't think the non-compete rule applied. I don't think that's going to work. Text of the rule is pretty clear to that effect. I think it's going to apply in gray areas, say, for example, where there are multiple owners of an entity that are passively involved but agreed to a non-compete as part of their governance documents, say in their LLC operating agreement or something like that. So with all of this in mind, what happens next? So there are several pending cases that are seeking to stop the FTC rule from going into effect. The rule was published at 3 p.m. on a Tuesday, and I believe by 9 a.m. the following day, the U.S. Chamber of Commerce had already filed its lawsuit to stop the FTC rule from going into effect. So that lawsuit is still going on. I believe that's in Texas, and there are actually 2 lawsuits in Texas right now. One of the courts in one of those cases has committed to ruling on the merits of the rule in early July. So we are all in wait and see mode here as to what that court rules and then the after effects of that. Now, if the rule is upheld, which is uncertain right now, it would go into effect on September 4th. So for proactive thinking employers, here's our recommendation on next steps. Employers should be reviewing their existing agreements with workers for potentially problematic clauses. And they should also be compiling a list of people that would need to be contacted if the FTC rule goes into effect. This is particularly important because the FTC rule, if it goes into effect, would require notice to impacted workers. And the notice could be via email if you have emails, and if not, then you have to figure out a way to deliver it to them, at least to the last known address you have on record. So I know all of this sounds probably upsetting to most employers, but it's important to note that there are ongoing protective measures for employers in the US. In particular, we suggest that people focus on protecting their intellectual property rights, and we think trade secrets are going to be even more important moving forward. As a brief reminder, trade secrets are any piece of information that is economically valuable to your company because it's not widely known and is subject of reasonable efforts to keep it secret. So what we're talking about would be your client lists, your proprietary formulas, any special way of doing things that you get an advantage of because it's not widely known, those things. And it's important to limit who can access those so that it's specific to role or realistically what they need to be doing. And it looks like we have a question.
So if a person has a non-compete now, when the rule goes into place, will that non-compete be valid?
So the question, if anyone can hear it, was if someone has a non-compete now, what will happen when the rule will go into effect? And the short answer is, unless they're a senior executive, it'll be struck down and won't be enforceable. So here's a brief recap here. Again, best steps as a proactive employer: review your existing agreements, figure out what's going to be banned underneath the FTC rule. Suggest you work with your attorney to make sure that you understand exactly what's covered and what's not. Keep in mind that non-competes are generally going to be banned. And then you have to recall that you have to look at the effect of the clause, right? So it doesn't matter if you're calling something a non-solicitation or a confidentiality clause. If the practical effect of the clause would be so onerous as to stop somebody from working, it's going to be treated as a non-compete. And lastly, remember this affects more than W-2 employees. It's going to impact independent contractors and anyone else that you have signing non-competes that's working at your business, practically. All right.
There's going to be another question. The question is, should we have our employees that have current non-competes sign any other type of agreement, like a non-solicitation agreement or confidentiality agreement?
So the question is, should our employees that have current non-competes sign other agreements, such as a non-solicitor confidentiality agreement? The short answer is yes. Non-solicits are likely going to be enforceable so long as they're narrowly tailored to your business. For confidentiality agreements, that's an extremely important step to protecting your trade secrets. It shows that you're using reasonable efforts by forcing your employees to agree that they're not going to steal your data or your confidential information. I think that the other important aspect to that is you also show your counterparties, whether it's a customer or a vendor, that you take confidentiality seriously, which is important as a general matter. So I think we're about halfway through our time, so we're going to touch on wage and hour now. Judy, did we get another question?
We're good right now.
Okay.
So wait a minute. Paige asked, are things like garden leave provisions affected to given their effect, but are supposed to be alternatives?
So
it's
the question is, what happens with gardening leave?
Mm-hmm.
So Paige, assuming by gardening leave, you mean that someone that remains employed but is still paid while they sit at home, I think that's still enforceable because it doesn't relate to a person's employment after their employment ends with their current employer. So probably still okay, but I don't know how many employers will want to pay somebody to sit at home for a period of time. Although I know that that is more common, particularly in places like Western Europe. Okay, on the FTC, well, that's the FTC rule in a nutshell in 16 minutes. But with respect to wage and hour, it must have been a slow news day because the update to the minimum salary required for people to not be eligible for overtime was issued on the same day in April as the FTC rule. So this wage and hour update, it directly impacts who's eligible for overtime. It increases the minimum salary that's required for someone to be exempt. It also ties the minimum salary to inflation so that moving forward, the minimum salary would be increased every 3 years. And it does something curious here in that it calls for 2 increases. First, an increase on July 1st to $43,888, and then another increase on January 1st to $58,656. And I'll get into a little bit why we think that there were 2 increases in a second. But I want to stress this point before anyone just writes down the salary number. The amount paid is not determinative for whether someone is an exempt employee. The duties tests remain in effect. The compensation amount is the only thing that was changed. So as a reminder, there's 3 prongs to the exempt test. Employers need to pay their employees on a salary basis. That means you're paying the same amount every pay period, regardless of the quantity of work or the quality of the work. So if you were saying that you're paying someone on a salary basis on a 40-hour work week, but they only work 35, so you knock them down 5 hours, probably not paying them on a salary basis, although there are some exceptions. The next prong of this test would be that the salary needs to meet at least those identified amounts. So right now it's $35,000 and change. It's going to go up to the 43,000 figure on July 1st and 58,656 by January 1, 2025. And lastly, the employee needs to meet a duties test. So when I'm talking white collar exemptions here, I'm primarily focusing on the 3 most common we see, which would be executive, administrative, professional. There are also other exemptions for computer sales staff, outside sales agents, that sort of thing. So I wanted to do a quick reminder on what these duties tests actually mean. So an executive employee would be someone whose primary duty involves managing an enterprise department or subdivision. They would need to direct the work of 2 or more employees, and they need to have the authority to hire or fire people or have their say or suggestions be given particular weight when it comes to hiring or firing. Administrative employees, they are performing office or non-manual work that's directly related to management or general business operations, and their role needs to require the exercise of discretion and independent judgment with respect to matters of significance. So you're thinking your CFO, your director of HR, roles of that nature. Someone that is just inputting data into a spreadsheet is unlikely to qualify for this exemption. The last one here within the so-called white collar exemptions that I want to talk about would be the professional one, and there's 2 subsets to this. There's the learned professional, which is someone that has advanced knowledge in a field of science or learning, and they got that knowledge by virtue of a prolonged course of instruction, typically at a university or college. The other aspect here would be for creative professional, and for that person, you're looking to the degree of creative or artistic freedom. So if you're looking at an animator versus a cartoonist, the cartoonist is probably closer to the creative exemption, whereas the animator is just animating something that's already drawn. Now, like the FTC rule, we are expecting, and in fact, the increases have been challenged legally, and it's uncertain as to whether the increases are going to survive those challenges. This is where the different rationale for the 2 pay increases comes into effect. So the increase on July 1st that would go to $43,888 is tied to the rationale that was used in 2019, which increased the minimum salary to the current level of $35,568. And that went through largely unopposed. So I think the July 1st increase is going to be more likely to survive than not. The January 1st increase to $58,656 is tied to the rationale that was used in 2016. And as some of you may recall, that 2016 increase was struck down because it was proposed to go up to $47,476. So it appears that the Department of Labor hedged their bets by proposing two different increases, one tied to rationale that sailed through a couple of years ago, the other tied to more tenuous rationale that was struck down by a court in 2016.
I think we have a question. So to be clear, are you saying that as of July 1st, all impacted workers that passed that duties test should be now increased if they're not at $43,000 to $388? Should we be increasing our employees' wages to that rate?
Well, it's a good question about should we be increasing salary to meet the minimum threshold or transitioning people to non-exempt? And the answer is it's going to depend on the business. It's a tough decision that employers are going to have to make. They're going to need to consider what the implication would be of needing to track time successfully versus the real dollar cost of increasing pay. They would also need to factor in overtime and the obligation to pay that out. So
there's a second part to this question too.
Okay.
How is it that as employers we position this with our employees?
Oh, it's a great question. Well, first of all, I don't know that you want to have any direct communications about pay increases until late June. And that's because the 2016 increase I talked about a couple of minutes ago that was struck down shortly before it went into effect. And in that instance, there were several employers that had already handed out pay increases in order to keep people as exempt employees. And they found out a couple of days later that they were no longer required to do that. So if you do decide to increase pay, it probably makes sense to hold off doing so until late June, closer to the July 1st cutoff point, so you understand what needs to happen and whether or not the rules are even going to be in effect at that point. But regardless, you should be reviewing your exempt employee salaries now so you can see who's going to be impacted at both dates and who would need to have their pay increased or who would need to be transitioned to a non-exempt employee status. And that's all I've got for right now. And I know I've been fielding questions so far. I think we've got a couple more minutes for additional questions if there are any.
So another question is, overall, given a variety of different industries that are out there, is there any advice you have in general for our business owners and business leaders that are on this call that they should do when they get off this call today?
Yes, I think the best piece of advice I could give to business owners would be sit down with your HR folks, if you have them, and start talking about who's going to be impacted underneath both of these. I would consider the increase in wages to be more important in terms of a temporal sense than the FTC non-compete rule right now, because that wouldn't go into effect until September, if it does at all.
Here's another question. Is there any grace period when these go into effect for business owners to meet updated requirements?
So the grace period is the amount of time between when the final rules were issued and when they go into effect. So we're currently eating up the grace period for the FTC non-compete rule and the increase in minimum salaries.
So this is the grace period.
This is the period to review and become compliant.
What if employers don't have HR professionals? Can they work with their payroll companies to help with some of this?
If employers don't have payroll or HR professionals, yes, they could work with their payroll company, but I don't know how much they would necessarily know about the duties tests and that sort of thing. So our phones are open and we'd be willing to help anyone if they have questions surrounding these items. All right, well, I think that's it. So most importantly, thank you all for attending today.
There is one more question from Russ. Are you gonna update us closer to the January 1st deadline? Also, does an employee need to challenge our companies if they are under the thresholds, and do you think any of them are aware of this?
Well, I'm sure that some of them are aware of the rule, Russ. Yes, I think we definitely be in contact with our clients as relates to any updates for either the FTC rule being struck down or upheld, or anything occurring with the wage and hour items. But largely it's wait and see, and I think prepare to make sure that everyone's aligned.
Preparation's key.
All right.
Any other questions?
Well, unless there are any other questions, I think we can wrap it up now.
Recording.
All right, and the recording will be available. I'm not sure if it's going to be on our website or mailed out, but thank you all for attending this morning.